Good morning. Thank you very much for joining us today in our very exciting first, and hopefully first of very many, quarterly legal and compliance updates for the block management sector. Just going to wait a few moments as the room starts to fill. We've got about 400 people who've registered for today's webinar, which is an astounding number, given that, as I said, this is the very first in the series. While it is the first in the FixFlow series, hopefully the FixFlow webinar series won't be new to a lot of you. But if it is, you can check out some of the webinars we previously held on topics of interest to block managers on our website. And also our guest today should not be a new face to you either, although I'll let her introduce herself in a moment. So today we are using Zoom, as you all know. Although you won't be able to ask questions because you're muted by default, and that's for the enjoyment of the other audience participants, we do want to hear from you. So please do ask us questions via the Q&A panel. My colleague Remy is on the line, she's collating them, and we will have 15 minutes dedicated to questions and answers at the end, just to manage expectations around that. So what we're looking to address are the themes or key questions that come out of the audience today. It's not for specific legal advice, although if you have any fact-specific or very detailed guidance required, I'm sure that our guest's law firm would be delighted to assist if you want to contact them. So this is our quarterly legal update, and the room is filling up very nicely. The disclaimer, as always, is that today is for general information purposes only. It is not and must not be construed as specific legal advice or official guidance, but if you want specific legal advice, then Cassandra's law firm would be delighted to assist. And with that, I'd like to hand over to our esteemed guest, Cassandra. Cassandra, would you like to introduce yourself and perhaps let everyone know of some recent changes?
Yes, good morning, Raj. Thank you very much to you and team at FixFlow for inviting me along today and to be involved in this ongoing project of these quarterly legal and compliance updates and webinars. Fantastic idea. I am a massive fan of sharing education and sharing knowledge within our industry. So kudos to you guys at FixFlow for hosting these webinars. Brilliant idea. And as I say, very glad to be involved in it. So thank you for asking me along. My name is Cassandra Zanelli. I am Solicitor and Chief Exec at the relatively newly formed Property Management Legal Services Limited. So I have had a busy couple of months in that I launched my own law firm, Property Management Legal Services Limited, on the 1st of December. So a busy Christmas and start of the new year for me. And thank you again for inviting me along today.
Brilliant, and delighted that you're joining us for this and the quarterly updates going forward. Just one point for the audience. So while a lot of you would have worked with Cassandra previously, please make sure you've got her up-to-date contact details, which will be sent out at the end of the webinar, which refer to her new law firm. And so the purpose of this is to share information and insight. We're trying to make it as practical as possible and as useful as possible for the block management sector. So if at the end of this, you could take a moment just to provide us with feedback on whether or not you found today's webinar useful, whether the topics were the kinds of things you want us to cover, we would really appreciate your feedback and your help in shaping this to make it as useful as possible for you, the audience. And so our topics today are managing general meetings, and this has come out of a flurry of questions that have been asked about how to manage them, how to run them effectively, and what to do in light of the changing requirements due to the coronavirus legislation. The second is we're going to cover off two recent cases, or one recent case and one upcoming case, in fact, on service charges, and there are some really important practical implications for those of you out there doing block management and service charge management, which I suspect is most of the audience given today's webinar. We're going to go through an update on the fire safety bill, and in fact it is constantly moving, but I'm sure Cassandra will be able to provide us with insights on what's coming. And we have 15 minutes at the end for audience questions, so please do submit your questions using the Q&A functionality within Zoom. And so with that, I'd like to hand over to Cassandra with, I guess, a very open question, which is, what are the current rules on meetings and AGMs? Can we host them virtually? What's changing? And so over to you, Cass.
Thank you. Thank you. Since we came into lockdown on 23rd of March last year, I have been asked certain questions with a huge amount of regularity. I think the first question that bothered everybody at the start of lockdown was how to go about serving service charge demands. And Raj, we covered that, didn't we, in a webinar that you and I were involved in last summer. The second question that I've been asked a heck of a lot is in relation to meetings. And that's a question that I'm still getting asked about at the moment. And I don't know whether it was the viral video that went around about Hansford Parish Council, whether that sparked everybody's interest again. But how to hold meetings in our current third lockdown is something that seems to be bothering lots of people. So you and I thought that it would be useful to cover it off in today's webinar. And so hopefully you don't end up with meetings that disintegrate into anything like it did at Hansford. You might not have a Jackie there able to terminate everybody in the meeting. So what we have at the moment is that we have, following the government's announcement on the 28th of March of last year, it was Alok Sharma. It was on 28th of March that he announced that the government would publish legislation in order to enable companies to be able to hold AGMs and to do so safely and consistent with the restrictions on movement and gathering that were introduced in order to stop the spread of, or to address the spread of coronavirus. And what Alok Sharma said is that companies would be temporarily allowed greater flexibility so that they could hold AGMs online and in some circumstances to postpone those meetings. So we had then the passage of an act called the Corporate Insolvency and Governance Bill, as it was, Act as it became, through Parliament, which received royal assent at the end of June and came into force on the 26th of June. So we have the first line on the slide that you have, the Corporate Insolvency and Governance Act 2020. That included a whole bunch of provisions in relation to, as the name suggests, corporate insolvency, but it also included some provisions that were relevant for our purposes regarding corporate governance matters, and particularly in relation to the conduct of meetings. And it did two things for our purposes today. Firstly, it allowed the deferment of AGMs, so annual general meetings. And secondly, it enabled companies to have a huge amount of flexibility in terms of their meetings. So those were the two things that the Corporate Insolvency and Governance Act did. We had after that two sets of regulations which have bolted onto the Corporate Insolvency and Governance Act so far as flexibility is concerned, but the main act itself, so the main event back in June of last year, did those two things in relation to AGMs and flexibility on meetings. Now, so far as AGMs are concerned, many management companies are going to be obliged, in accordance with their MEMARTs, their Memorandum and Articles of Association, to hold an annual general meeting. And the requirement on the part of a management company to hold an AGM is going to be governed by its MEMARTs. So Companies Act did away with the statutory requirement for residence management companies, kind that we're dealing with, to hold an AGM. It's driven by the Memorandum and Articles of Association of a company. So one of my soapbox points, as I'm sure people watching this might know, is that I think that agents who are managing on behalf of management companies should do a MEMARTs review as well as doing a lease review when they take over the management of a block, so that they know whether there's a requirement to hold an AGM, for example, what the quorum is for general meetings, how many directors are required, those kind of housekeeping things that you really need to know to be able to manage a company properly. But back to AGMs under the Corporate Insolvency and Governance Act, sorry. What the Corporate Insolvency and Governance Act did is that it allowed temporary changes to be made to the requirement to hold an AGM. In other words, to postpone that requirement to hold an AGM for a period of time. I should flag at this point that that period of time has now expired. So what it did, it was paragraph 5 to Schedule 14 that permitted companies to extend the period of time in which they were required to hold an AGM. So if an AGM was required to be held between 26th of March and 30th of September, then that requirement was read that the AGM had to be held by the 30th of September. It knocked it back to the 30th of September. So that was a requirement to be read that it had imposed and had always imposed a duty on the company to hold the meeting by the 30th of September. As I say, that was not extended further by either the first set of regulations mentioned on the slide, or indeed the second set of regulations. So as of the 1st of October 2020, companies aren't able to take advantage of those provisions of the Corporate Insolvency and Governance Act to delay their AGM. You were allowed to delay it for a period of time over the summer. You're not allowed to delay it any longer. That relevant period hasn't been extended. So AGMs you have to hold. But when holding AGMs, you are permitted, and indeed any general meetings of the company, not just AGMs, you are permitted certain flexibility in how you hold those meetings. So the lockdown restrictions that we had that came into force in 2020 and have carried on throughout 2021 as well, have imposed restrictions on our daily life, hasn't it? It's imposed restrictions in relation to movement and gatherings, and that's all to stop the spread of coronavirus. And we're working to the third set of lockdown regulations at the moment, aren't we? Where we're not permitted to leave home except where it's necessary. Based on what the government announced, was it last week, Raj, a week before? I've lost track of time at the moment.
A couple of weeks back.
Yeah, a couple of weeks ago, wasn't it, that Boris made his most recent announcement, his roadmap out of this, is that we're probably going to have meetings on a closed basis until at least the 17th of May, if not beyond that until the 21st of June. It may be beyond that, who knows? So it's really important that people are aware of the flexibility that companies have under paragraph 3 to schedule 14 in terms of being able to hold virtual meetings in lieu of fully physical meetings. The headline points, and this is what companies need to be aware of, is firstly, the meeting need not be held in any particular place. So that allows you, therefore, to have your virtual meetings. The second headline point to be aware of is that the meeting may be held and any votes may be permitted to be cast by electronic means or other means. So we can raise our hands on Zoom in order to cast a vote, or we can shout up on Zoom in order to do that. That there are no restrictions so far as the casting of votes are concerned, or indeed the holding of meetings. The Act specifically allows meetings to be held by electronic or indeed other means. The third headline point to be aware of from paragraph 3 to schedule 14 is that the meeting may be held without any number of those participating in the meeting being together at the same place. Good example of that is the Hansford viral video that we've all seen, where you've got different members of the parish council all sat in their living rooms taking part in the meeting. The Act permits that. It allows those who are participating to be dotted around in their living rooms, whether that be at their homes or if they're abroad, it doesn't matter. The fourth headline point to be aware of so far as the Corporate Insolvency and Governance Act is concerned is that a member of a company doesn't have a right either firstly to attend the meeting in person, secondly to participate in the meeting other than by voting, or thirdly to vote by any particular means. So that enables agents and management companies to have virtual meetings, and it doesn't matter that people are scattered to the four corners of the country, and it doesn't matter that they can only participate electronically and vote electronically as well. The Corporate Insolvency and Governance Act permits that and allows that. Now, that relevant period under the 2020 Act ran until the 30th of September. It was extended under the, I've put them on the slide because they're not the easiest of regulations to remember the names of. It was extended firstly under the Corporate Insolvency and Governance Act 2020 Coronavirus Extension of the Relevant Period, Regulations 2020. It's extended until the end of December, and then it was extended again until the 30th of March by the Corporate Insolvency and Governance Act 2020, Coronavirus, Suspension of Liability for Wrongful Trading and Extension of Relevant Period, Regulations of 2020. Lawyers come up with some really interesting names for stuff, don't they? So we're working at the moment under the extension brought about by the last set of regulations on your slide. So we have the ability to hold those virtual meetings until the 30th of March 2020. It may be that is extended again. So what happens next? Roger, I don't know if you can slip to the next slide, please.
Of course.
I thought it would be useful because there's nothing being announced yet by government in relation to what comes after the 30th of March. And if we go by what Boris said in his roadmap that he talked about recently, it's likely that we're going to need something to fill the vacuum that comes after the 30th of March, because we're not going to be able to hold fully face-to-face meetings. I think that's inevitable. So what we do have at the moment is some discussion papers that are doing the rounds, which talk about what different organisations think could and should happen following the 30th of March. So yeah, have details of those on the slide. I thought it would be useful to put details so that anybody watching this webinar can go and take a look at those if it's something that they're particularly interested in. We have, first of all, on the 28th of January, so a month or two ago, the GC 100 published a discussion paper, Shareholders Meetings, Time for Change. And that discussion paper talked about the limitations of the current format for AGMs, and it advocated a framework that would permit companies to choose a meeting format and which they consider best for their stakeholders and best for their shareholders. And this is probably something that lots of managing agents can relate to, but it recognised that the additional flexibility that had been introduced by the Corporate Insolvency Governance Act has shown that virtual and hybrid meetings are possible. So where we're faced with adversity, we have made it work, and it showed that they're effective and that they allow for increased involvement and engagement with shareholders. And it references the fact that historically there have been low attendance figures at AGMs, but now that we're doing them virtually, the attendance figures are higher. And Roger, I don't know about you, but I speak to clients about this with some frequency. And anecdotally, I hear as well that because meetings are being held virtually now, and it's much easier to dial in to a virtual meeting at 7 o'clock on a cold and Wednesday night than it is to schlep out for an hour's drive, that more people are attending those virtual meetings. So it does seem to be helping with engagement and helping get those attendance figures up. The paper itself notes that we've now had an opportunity to broaden engagement from geographically diverse shareholders and stakeholders, and that this is an opportunity, therefore, to update regulation to better meet the needs and expectations of companies and the communities in which they operate. What's interesting as well with the discussion paper from January is that it includes a draft code, and it's a draft code of best practice regarding electronic participation at either hybrid meetings or virtual meetings. It's the draft code that's included within that discussion paper gives some pro forma explanatory wording for proposals to amend articles of association to permit virtual and hybrid meetings, and for amendments to articles so that you can postpone those virtual or hybrid meetings if you're experiencing technical issues, for example. So an interesting discussion paper to read, and an interesting draft code to read as well, particularly if people are thinking about making any amendments to their articles of association that would permit them to carry on holding either hybrid meetings or indeed virtual meetings going forward. A good read.
Absolutely brilliant. Thank you so much, and there's a huge amount of detail in there just for the audience. So the first thing is, by registering for this, you will receive a recording in due course, and I suspect this is the source of information, particularly with the discussion papers that you may want to circulate to your team. So that will be coming out, as will a written piece shortly after this, which will provide some further detail and context. And so, Cass, am I right in saying that the synopsis might be, there was a period in which AGMs or general meetings could be deferred, and that's no longer the case. They have to occur. There is currently, for a finite period, a set of regulations in place that support the provision of virtual meetings. So not just how they happen, but also stopping people who would be entitled to attend, stopping them from thwarting it by demanding that they vote in a specific way or other things. But actually, the undercurrent is that this may be better for the general members or the attendees. And I would sort of add quite possibly better for the sector, for residential block managers generally, because the need to attend in person is both a positive and a negative. So it allows you to build the relationships, but it's quite hard to do it on consecutive evenings, and it sort of challenges the work-life balance. But there is currently no commitment from the government to extend, although from what you've just described, it sounds like there is a movement towards extending so that virtual becomes the new normal. Is that right?
Yeah, absolutely. In a nutshell, yeah. We should swap places. You could do this.
Absolutely could not. That was phenomenal and a huge amount of detail. So hopefully that's useful. I'm just going to pause there to remind the audience, please do submit your questions via the Q&A panel. We have 15 minutes at the end. My colleague Remy is reviewing them and we'll sort of consolidate them, and we'll deal with any sort of themes that come out of this. One of the themes that I strongly suspect, if you're happy to jump to it now, Cass, is around the notice. So providing notice of meetings, and what happens if someone who would be entitled to attend says they have no internet connectivity. These are the sorts of questions I get asked. I don't know if there's the sorts of things that are crossing your desk.
Yeah,
as well.
yeah. Can I mention, just before we jump onto that, Raj, we talked about maybe amending the memorandum and articles of association so that it allows for virtual or hybrid meetings moving forward. One of the things that I see with some regularity is how memorandum and articles of association are amended. So just to deal with that point really quickly, you amend your mem and arts by passing a special resolution. You pass a special resolution at a general meeting of the company. A certain amount of irony there that you need a meeting to amend your mem and arts, but that aside, pass a special resolution, which is at a meeting of the company, a quorum meeting of the company, and it needs to be 75% of those who are present at the quorum meeting that agree to that resolution. What I wanted to flag is that a special resolution, because it's special, needs to be filed at Companies House, and it needs to be filed at Companies House within 15 days of it being passed. And it's a criminal offence that's committed by the company and by the officers of the company where that special resolution isn't filed at Companies House. People think about Companies Act and don't realise that the Companies Act is littered with lots of criminal offences that can be committed by companies and by officers of a company. And this is an example of one of them. So it's really important that if you do pass a special resolution, that you get that filed with the Registrar of Companies. So get it filed with Companies House within 15 days. Otherwise, you're committing an offence. And none of us want to commit offences or get fined for doing so. That comes up quite a bit. So I wanted to emphasise that. And also, as I say, there are lots of other offences littered throughout the Companies Act. If you Google it, there are lists of them. And please make sure that you're not committing criminal offences. Criminal offences are bad.
Thank you.
Sorry, I'll jump off my soapbox at that point.
And I guess just very quickly, if you're happy to cover off the point around providing notice for people entitled to attend the meetings, and also what happens if somebody says that they are unable to attend a virtual meeting for lack of equipment or connectivity or the like.
The Companies Act is one of the acts actually that deals with the ability to serve people electronically. So it's actually moved with the times, unlike some of the other acts that we deal with within our sector. So there is the ability to serve people electronically, and I'll cover this off in the notes that we circulate afterwards, Raj. That's probably better than bombarding people with all sorts of law now, but there is the ability to do that. And as I say, we'll cover it off in the notes.
Excellent, thank you. Shall we move on to the next section of today? So just as a recap, we were talking about managing general meetings. The next area is to look at a case that has recently been decided on service charge, and one that's coming through at the Court of Appeal. We're then going to look at the fire safety bill, and we will work towards having 15 minutes at the end for Q&A, because I know there are lots of questions coming in. So Cassandra, service charge. How does the January Court of Appeal decision in Aviva and Williams affect service charge recovery?
Yeah, I spoke a lot about the Aviva case probably around this time last year when we were dealing with the upper tribunal decision. And in the Aviva case, I don't know if you can flick to the second slide, Raj. if you can flick to the next one,
Oh,
apologies.
sorry. Yes.
In the Aviva case, you have what's a relatively common construction in relation to service charge provisions and apportionment of service charge costs. So in the leases for the blocks that you manage, you'll have service charges apportioned in all sorts of different ways. So it might be a fixed percentage that a leaseholder pays towards the overall costs. It might be a fair and reasonable proportion of the costs, might be an equitable split. Your leases will tell you, and as we know, every lease is different. But what we had in Aviva and Williams was a clause that says you will pay 0.7135% of the insurance costs or such other part as your landlord will tell you, ditto for building service costs and ditto for estate service costs. What we had following the upper tribunal decision round about this time last year was that the upper tribunal said that the second half of those lease clauses were void and that they were to be deleted, therefore leaving a situation where the landlord was stuck with just the first part of the clause that gives the fixed percentage. And I know that lots of managing agents have these kind of clauses and they rely on the, I call it wiggle room, but they rely on the wiggle room part of the clauses to be able to adjust those service charge apportionments, and post the upper tribunal pre-Court of Appeal decision, they couldn't do that. So that's why I wanted to talk about this case today, because a lot of agents will have probably heard me talk about it last year saying, ignore the second part of the clause, it's void, it's deleted, you're stuck with the first part. We now have the Court of Appeal decision, which has reversed that a little bit. So it's not as worrying as it perhaps was this time last year. Can we flip back to the first slide? Sorry, Raj.
There we go.
Dead bossy. Before we kind of look at the nuts and bolts of the case, it's probably worth reminding ourselves about what the Landlord and Tenant Act 1985 says. And this is the bit that gives the first tier tribunal, if you're in England, or leasehold valuation tribunal, if you're in Wales, the ability to determine if a service charge is payable, and if so, by whom, to whom, the amount, the date at or by which it's payable, and the manner in which it's payable. And that ability to make that determination is based on both actual costs, so costs that have actually been incurred, and also budgeted costs, so anticipated expenditure as well as actual expenditure. And subsection 6 of section 27A says this. It says an agreement by a tenant of a dwelling, other than as a post-dispute arbitration agreement, is void insofar as it purports to provide for a determination in a particular manner or on particular evidence of any question that may also be the subject of an application under subsections 1 or 3. We kind of ignored that a lot as lawyers because we looked at it and went, not really quite sure what that means, so we'll ignore it. Until we got to the cases a few years ago in Windermere Marina and Gator and Wellington. And we then learnt all about what that clause actually meant. And those cases of Windermere Marina and Wellington set the ground really for what section 27A6 meant, and Williams and Aviva build on that. So the question for the Court of Appeal in the Aviva and Williams case was whether the landlord was restricted to the specific percentages set out in the lease, so the 0.7135, whatever it was, or whether the ability to specify a different percentage, so to use that wiggle room that you have in the second half of the clause, whether that is transferred from the landlord to the tribunal, so whether the tribunal can exercise that wiggle room that's in the second half of the clause. So you have, in this case, a mixed-use development in Southsea. I spent my formative years in Southsea. I love Southsea, down in Portsmouth. And you've seen in the second slide the kind of clauses that were in those leases. So with the fixed percentage and then the wiggle room as the second part of that clause. And in the Court of Appeal, the court reminded itself of what had happened in the earlier cases in Windermere Marina and in Gator. And in Windermere Marina, the leases obliged each lessee to pay a fair proportion to be determined by the surveyor of the lessor whose decision shall be final and binding of all expenses of all communal areas. So it didn't give a fixed percentage in Windermere Marina. Similar kind of thing in Gator, because in Gator, the lease required each lessee to pay a due and fair proportion of the service cost, such proportion to be determined by the landlord or its surveyor, in each case acting reasonably. And in both of those, so in both Windermere Marina and in Gator, the upper tribunal held that the effect of section 27A6 was to delete those words to be determined by surveyor, leaving it for the tribunal to decide what the percentage should be, what the fair proportion of the service charge should be. So as the tribunal put it in Windermere, it said section 27A deprives the landlord's surveyor of his role in determining the apportionment. The lease is to be read as if the method of ascertaining a fair apportionment was omitted altogether. So we start talking about deleting certain parts of clauses. It's all set out in the note that's coming. So in the upper tribunal in Aviva, what the upper tribunal said is that that second part of the clause was deleted. That second part that said all such other parts as may be determined by landlord surveyor, that was deleted, and the landlord in Aviva was left with just being able to recover that fixed percentage. Landlord wasn't happy with that because he wanted to be able to recover different to what the fixed percentage of cost was. So that's why we end up on appeal to the Court of Appeal. And what the Court of Appeal say is that they looked at what section 27A6 means and how it operates. And they say that there is a clear thread that runs through the previous decisions of the upper tribunal, saying that section 27A6 is concerned with no more than removing the landlord's role or that of his surveyor from the decision-making process. That doesn't deprive the FTT of the ability to put in what they think the appropriate percentage should be. It just takes that ability away from the landlord. It's transferring a role from the landlord to the tribunal. So the effect of the upper tribunal's decision had been to deprive the FTT of its jurisdiction over service charges. That's not what section 27A6 was intended to do. What section 27A6 does is that it takes that role away from the landlord, and that leaves a vacuum. And that vacuum is then filled by the FTT. So the function of making that determination as to what a fair and reasonable proportion is then fulfilled by the FTT. It's not fulfilled by the landlord. And if anybody, whether it's landlord or lessee, has a problem with that, a problem with the percentage that's being imposed, then they can refer that to the FTT. Either the landlord can do that or the lessee can do that. So if you flick to the next slide, please, Raj. We're no longer in a situation where the landlord is limited to recovering just the fixed apportionment, because Court of Appeal say that the second part of the clause still has effect, but it's the determination is a function that's transferred to the tribunal, and it's not a function that sits with the landlord. I wanted to, just in case people were worried about the upper tribunal decision and weren't relying on that second part of the clause, that second part of the clause isn't deleted, but the vacuum that's created by section 27A6 is filled by the tribunal rather than being filled by the landlord.
Thank you. Just before we move on to the next case, so in the case where a landlord does want to exercise the discretion to vary the percentage, say fixed percentage, or to be able to determine a different percentage, ought they go with what they think, or ought they be asking for determination or guidance, or how should they approach this in practice if they want to not go with the fixed percentage and instead to rely on the second part of that clause?
Yeah, they're able to do that, and if it can't be agreed, so if the landlord and the leaseholders can't agree what that should look like, then either party can make the referral to the tribunal, and the tribunal can step in and impose what it thinks. Why this was quite so controversial at the time is that the tribunal normally exercise a review function So they look at what the landlord does in relation to how it's incurred service charges and say, does that fall within the range of reasonable decisions that's afforded to landlords? This is different because the tribunal import what they think rather than reviewing what the landlord has done. That's why lawyers thought it was really interesting when Windermere Marina came out. And we got to know what 27A6 was all about.
For the first time. So I'm going to move on to the next case, if that's okay. So what can we expect from next month's Court of Appeal case on utility charges? So West India Quay and East Tower Apartments.
Yeah, the Section 20B is one of a raft of statutory restrictions on the recovery of service charges. All agents are familiar with those because you have a bunch of contractual restrictions, which are lease specific, and then a bunch of statutory restrictions that apply in every case. One of those statutory restrictions is the 18-month rule, so-called 18-month rule, and that's set down by Section 20B of the Landlord and Tenant Act 1985. It's one of the ones that people worry about the most, because if you get it wrong and you fall foul of the 18-month rule, then the service charges become stale, and stale service charges are unrecoverable. So we have, at the moment, lots of cases that have littered the courts and tribunals about how Section 20B operates, when costs are incurred for the purposes of Section 20B, how Section 20B2 notices work because they stop the 18-month clock from running. And we have next month, it's the middle of next month, so mid-April, a case again looking at the operation of Section 20B. So it will be an interesting one because it's been a little while since we've had a Section 20B case, apart from the upper tribunal one in this. So it'd be interesting to see what threads the Court of Appeal pull together in relation to Section 20B and whether it impacts on how we're approaching it, or indeed how we should be approaching it, what it means for us in practice. So look out for that one coming, no doubt. Raj will cover that off in our next quarterly compliance update.
That would be brilliant. Thank you. And just so as a reminder, please submit your questions via the Q&A panel. They're stacking up, and my colleague Remy is working frantically behind the scenes to consolidate them into the themes that we can put back to Cass for the final 15 minutes of today's webinar. And as a reminder, this is the first quarterly update we've done. We would love your feedback at the end. So if you could take a few moments at the end to provide feedback to let us know if we're on the right track. The whole purpose is to add as much value and insight for you, the block management audience, as possible. So if there's anything we can do to make this more valuable to you, please let us know. And with that, I'd like to move on to our final theme for today, which is an update on the fire safety bill. So I know the answer to this is yes, but we're going to delve into it in a moment. So are there any updates available on the forthcoming fire safety bill or building safety bill? What should block managers be doing now to prepare? And this was, I think, mainstream news over the last couple of days. So if I hand over to you, great to hear your thoughts.
It is. It seems that every day there's an update, isn't there, in relation to either the fire safety bill or to the building safety bill, or with fire safety matters generally. No doubt, Roger, if we were doing this tomorrow, that what we say and what we discuss now would be entirely different.
And it's not, it is across mainstream media and has a huge amount of political capital invested. So what was supposed to be a clarificatory bill in terms of the fire safety bill is now morphed into something significantly different. But what are the tangible updates, and what can the audience do now to prepare for the fire safety bill and the building safety bill that are coming down the track?
Absolutely. I think it's worth noting at this juncture that the fire safety bill, as you say, was designed to clarify the fire safety order. And fire safety bill therefore applies to all residential blocks. That differs from the building safety bill because the building safety bill, albeit it introduces a new regulatory regime in terms of buildings and building management, and also introduces this quite thorny concept of the building safety charge that lots of people have commented on and criticised, and I'm not sure that it works as a building safety charge either. I have laid some criticisms at the building safety charge door, but the building safety bill applies to buildings in scope. So that's, I suppose, the difference from a managing agent's point of view, in that fire safety bill will apply to all the blocks that you're managing. The building safety bill is going to apply to blocks in scope, and blocks in scope we're anticipating to be 18 metres and above. But the fire safety bill, the intention of the fire safety bill was to clarify certain points from the fire safety order and to make it clear who was responsible for things such as external wall system, balconies, that kind of thing. So it was supposed to be a really quite simple bill for clarification purposes. What's happened is that this is a political issue, isn't it, at the moment, in terms of fire safety, remediation works, who pays for those remediation works, and there have been various amendments proposed to the fire safety bill, and we're at the ping pong stage at the moment. Those amendments that have been proposed relate to cost recovery in relation to the remedial works. And to paraphrase those amendments suggest that the building owner would be unable to pass the cost of the remediation works onto the leaseholders, save where the leaseholders are the building owner. Those of you who have been following this, and I know that many of you have and are following it, those amendments were rejected last week. My understanding is that there may be more amendments that are going to be proposed as a result of that. So in terms of what managing agents should be doing, it really is keeping up to date with these, because things are changing on, if not a daily basis, then certainly they're changing on a weekly basis in terms of how this legislation is moving forward. And government are making announcements with some frequency, as you will no doubt all be aware.
Thank you. And we're going to be doing a separate webinar. Details of this will be at the end on the building safety bill and the role of the building safety manager. And I was just looking down because the number of questions has been quite astounding. So if you're happy to, we're going to do some quick fire ones and try and pick up some of the themes from the audience. You still do have time to submit any questions you have. We are going to run for the next 19 minutes answering as many of your questions as we can. Although I fear that we may not be able to get through all of them. So the first is going right back to the beginning, and we were talking about managing general meetings. So while the government is talking about or consulting on the ability to hold virtual meetings in the future, is it open to companies to change their mem and arts to allow them to continue virtual meetings irrespective of the outcome of the consultation?
Yeah, and the draft code that I mentioned that accompanies that GC 100 report that came out in January, that even gives suggested wording for companies that might want to amend the mem and arts to be able to cater for either hybrid meetings, so where you have some people who are present together and then people who are scattered to the four corners of the country, or where you have pure virtual meetings, so everybody separate. If you are going to amend your mem and arts, though, as I say, you need to pass a special resolution to be able to amend your mem and arts. You can pass that special resolution by either calling a general meeting. There are certain hoops that you will need to go through when you're passing special resolutions. So you can either do that by calling a general meeting, making it quorate, and then passing the special resolution, or you can do it by written resolution as well. I'm surprised that we haven't had more written resolutions whilst we've been in lockdown, but we don't seem to have done.
And I think that is a point that's come up from a couple of people. So as an alternate to the special resolution being passed by vote, there is a written resolution procedure that can be carried out in order to pass that, as long as you've got sufficient votes and it is quorate and meets the other requirements. But yes, special resolutions are a valid way of passing written resolutions are a valid way of passing resolutions. One of the questions
I think people find it difficult. If you're dealing with a block of 400, to be able to pass a written resolution, you need more than 75% of those 400 to sign and return it within the time frame set down. So some of your bigger blocks, written resolutions aren't really going to be a practical solution. If you've got a smaller block and an engaged block, then written resolutions certainly are a viable way of dealing with this.
I'm going to pick up on a secondary point from that, which is somebody wrote to Companies House to ask if Zoom or video AGMs were acceptable, and the response they received was no, because they're not a tried and tested method. I think that the question that is being asked is, Did they get wrongly advised by Companies House what could or should they be doing?
I haven't seen the question and how it was phrased that went through to Companies House. It's very difficult for me to criticise
Of course.
Companies House. What I would say is I'd refer you back to Schedule 14 to the Corporate Insolvency Governance Act that sets out what people's expectations can be in the current lockdown that we're in terms of how they can participate and what rights they have in relation to participating in meetings. And it does make clear that meetings can be held electronically.
I think one of the questions that's been asked has already been answered, which is it is acceptable to do email service of notice for AGMs because that's permitted under the Companies Act. So hopefully that's already been covered off. A couple of attendees have asked a similar question, so I'm going to sort of paraphrase it, which is the members want to defer their AGM until they can meet in person. They've now passed the period within which they ought to have held their AGM. What ought we be telling them to do?
To hold their AGM.
Yeah.
Hold it virtually, but to hold their AGM.
And the rationale might be that the attendees would not be able to attend because they don't have the infrastructure connectivity equipment to do a Zoom meeting. Notwithstanding that, they should still proceed to hold the AGM because it is a requirement.
Yeah. Can they make sure though that it is a requirement? Because I know that lots of companies hold a meeting annually, but they do so because that's a matter of good practice from a corporate governance point of view, rather than being an actual requirement that's set down by the Mem and Arts.
And this goes back to your Mem and Arts review in the way of a lease review at the outset to make sure you understand the rules of the game, because the rules vary company to company.
Yeah. It's much easier though to understand Mem and Arts once you've read one or two sets of Mem and Arts. They look and feel the same, and indeed, in some cases are identical where model articles have been used. It's very different to when you read a lease, because leases differ from block to block to block, and they look and feel different. Mem and Arts, as soon as you develop the knack of reading them, it's a lot easier. Don't be frightened by Mem and Arts, is the message, I suppose.
Thank you. I'm going to move on to the next flurry of questions, which are about recovery of service charges. So going back to the Aviva case, that was an example where there was a fixed percentage or such other percentages the landlord may reasonably determine, so a discretionary limit to it. What happens if there is no fixed percentage and it is simply such amount as the landlord may reasonably determine or a surveyor may reasonably determine? How would that work in practice? I guess stepping it through, getting agreement and then absent agreement.
Yeah, the landlord has to make the call as to what a fair and reasonable proportion is in his opinion. What 27A6 says is that decision isn't a final and binding decision, because the tribunal have the ability to say if a service charge is payable, and if so, by whom, to whom, the manner, the amount, etc. So in the event of disagreement in relation to what a fair and reasonable proportion is, there's the ability either on the part of the landlord himself or on the part of any of the lessees to make the application to the tribunal for a determination in relation to those service charges, and be aware that the tribunal won't review what the landlord thinks is fair and reasonable. The tribunal will port in their decision as to what they think the apportionment should be.
And are you seeing many cases like this at the moment, or are you getting lots of inquiries around this, or is this yet to bubble up?
It bubbles up every so often, and particularly in a fire safety context where it tends to be where solicitors who have drafted the leases haven't been able to add up to 100. So where you have fixed apportionments that might add up to 90 point something percent. I mean, in some cases, it's even as low as 80 and into the 70s. So that there is the need to be able to rely on that second part of the clause, which is what caused some concern when we had the upper tribunal decision in Aviva and Williams, because that second part of the clause went and was deleted. That position's now been corrected as a result of the Court of Appeal case, but it tends to be that kind of context where people get nervous.
Thank you.
So you don't have 100%.
Could we step through that just as an example? So if the fixed proportions added up to, say, 90%, but there was a discretionary element as well, the steps would be for the landlord to say what they think is a reasonable proportion to make it add up to 100%, to seek to agree that with the tenant, or the leaseholders more generally, and failing that, to then seek determination where the upper tier tribunal will not review the landlord's assessment, but instead will go back to first principles to work out their own assessment in order to get to that 100%.
Pretty much, yeah. Yeah.
Okay.
So the landlord says, this is what I think, these are the proportions that you, lessee, are going to pay. Lessees go, no, we don't like those, and then make the application to the tribunal. Or the landlord goes, I'm going to spend huge amounts of money on a massive project of major works. I'm going to go and get a predetermination before I do that. That's probably an important point to flag as well, is that we talk about tribunals where we go because leaseholders are challenging actual costs incurred. It's probably worth noting that tribunals have the ability to determine costs before they've been incurred, so based on budgeted and anticipated expenditure. So if you are a landlord who is relying on that wiggle room part of your lease, or if you're going to spend huge amounts of somebody else's money anyway, because service charges are somebody else's money, then it's always worth thinking about going to the tribunal under subsection 3 and saying, we intend to incur these costs. Please, can you tell us that service charges are payable, and by whom, to whom, the manner, the amount, the dates, etc. Use the tribunal for predeterminations. I think the tribunal has been historically woefully underused for that. Where you are spending huge amounts of somebody else's money, think about going to the tribunal, presenting it to them and getting their determination. Better to know before you spend all that money whether you can or can't do it.
Absolutely. I've got a very general question that's come in on the fire safety bill, and I'm going to extend it to the building safety bill as well. So for pressing block managers on the call, what is the best way for them to keep up to date? Because this is what I describe as a moving feast. It's highly political. I know that there are lots of committees and consultations and special meetings and the like, but this is coming down the track. The sector is going to change as a result. The relationship, I think, with leaseholders is going to change as a result of this pretty profoundly. What's the best way of keeping it up to date so that they can prepare their businesses for the change that's coming?
Oh gosh, I suppose it is doing things such as this. So coming to webinars such as this and learning a bit about the changes that are coming down the track. Coming to the webinar that you're doing in a couple of months' time, or next month, I forget the date that it is, where you're looking at the role of building safety managers, because that's going to impact on managing agents, how they perform that role, whether they do perform it in-house, whether they outsource that role. Huge amounts of things to consider and that are impactful on managing agents as a business, how they handle that. There's lots of training out there from organisations such as ARMA, and IRPM are doing a huge amount of work in this sector as well. Nigel Glenn and Andrew Bulmer are really doing a huge amount of good work so far as that's concerned. I say ARMA because I'm involved in some of the fire safety training that they do, so plug there for ARMA from me. But yeah, there are lots of updates that are going out from organisations such as ARMA that some of your people watching this will be members of, from IRPM. And again, some of the people watching this webinar will be IRPM members of whatever designation. Keep up to date with those, and indeed with organisations such as Fixed Flow doing this webinar. Lots of changes. I subscribe as well to the updates from government, so I get lots of emails in my inbox on a daily basis telling me about the new stuff that's happening. I tune in every so often as well. I was watching Select Committee over the last couple of days where there's been different evidence that's been given. They're always really useful to watch, just to kind of see government's thoughts are on the questions that it's asking and what the stakeholder organisations are saying about things as well.
Absolutely.
What do you do to keep up to date with it all?
So we are, I can't remember what the designation is, but we're members of ARMA, so we have access to the resources which are incredibly useful. We read stuff from IRPM. very, very similar to you. I guess one of the key things that I suspect goes without saying, knowing a lot of the people in the audience, is check the validity and accuracy of your sources, because with the fire safety bill and the building safety bill being so highly politicised, there is an increased likelihood, or a greater likelihood than other pieces of block management legislation or property legislation, for people to put their own spins on. And so I would encourage you to go back to the primary sources, whether that is the Hansard debates or the select committee videos, or don't take an organisation or a media organisation's spin of what they think is happening, because everybody's got hidden agendas in this. This goes to the safety of people in buildings and your livelihood in industry. So I'd really encourage you to go back to primary sources and to trusted sources, because I can't see the media furore dying down anytime soon.
Yeah, I find it really interesting to go back and watch those videos on select committee, stuff like that. You can see the kind of questions that's coming to those who are taking part. There's such a huge range of people that are taking part and being interviewed as well. It's really interesting stuff. I find it interesting as a lawyer.
I find it interesting as a recovered lawyer. With that, I would really like to thank you all very, very much for attending our first quarterly legal and compliance update for block managers. And huge thanks to Cass for giving up the time in preparing for and delivering today's presentation. Once again, I would love it if you could take 30 seconds at the end of this to provide us with feedback. So we want to continuously improve. We want this to be really valuable and helpful to you. So please let us know what you think. We'd really appreciate that. In terms of the next webinar in the series, it is Building Safety Reform, with a couple of people who were mentioned and one who wasn't. So Andrew Bulmer, CEO of IRPM, Nigel Glenn, CEO of ARMA, and Sean Lundy, Director of Strategy and Innovation at Tetra, and phenomenally well known across the sector and a visiting lecturer at university. So Building Safety Reform, what does this mean for block managers? It's on the 27th of April. You will all, by virtue of having been here today, be invited to that. Please do attend, and please do invite your colleagues if you think it's of interest or relevance to them. We are expecting some more tangible and material updates to both the fire safety bill and the building safety bill in the intervening period, obviously subject to parliamentary available time, but we think that things are about to accelerate for both. And please do get in touch with us. So connect with us on LinkedIn, Facebook, Twitter, YouTube, apparently. YouTube is actually quite relevant because we've had a series of block management specific webinars. Practice, how do you attract more clients? How do you win pitches? What legislation's coming? How do you train people? How do you manage apprentices? And how do you get apprentices? All of them are on our YouTube channel. If you like it, hit the subscribe button. And for any feedback, please let us know via email to research@fixflow.com. And thank you all very much for attending. Please take 30 seconds to provide us with feedback. And Cass, it's been phenomenal to chat with you. Thank you very much.
It's been a pleasure. Thank you.
Have a great day, everyone.
Take care.
Bye.